This is Michael Popak, Legal AF, with an update on the gag order imposed on Donald Trump last night. Along with everybody else, we were able to tell you that there was a reimposition of the gag order by Judge Chutkan on Donald Trump in the D.C. election interference case. We just couldn't tell you exactly what that order looked like because nobody had a copy of it. This might sound ridiculous in 2023, but the internet was down, or the website that we used to obtain these documents was down. But now we have them, and now we can report it's much worse for Donald Trump than even I imagined when I reported yesterday that he had the gag order reimposed. It's because of her analysis and the integrity of her analysis. And she really sets up Donald Trump in two ways, Judge Chutkan. One, now that she's forced him to litigate the matter with her, with sets of briefings, with filings, with a record now being established, with a hearing, now when he runs to the appeals court, inevitably, to the D.C. Court of Appeals and says, we need a stay. The issue is not the appellate court coming out on a fresh record, if you will, and making the decision for themselves. Now it's them reviewing whether Judge Chutkan, based on that complete record now developed below by her, whether she abused her discretion as a trial judge. That's the standard, abuse of discretion. And it's a very difficult thing for a litigant to convince an appellate court that a trial judge, given broad and liberal discretion, has somehow abused it. Masterstroke by Judge Chutkan. Rather than having Donald Trump run off where she can't control him at the Court of Appeals, she forced him to completely litigate the issue of the stay of the gag order with her, and then that puts him back on his back foot when he's trying to argue for a stay with the appellate court. Chef's kiss to Judge Chutkan. The second thing she did is she's completely rejected his First Amendment argument, which is now morphed into, I, Donald Trump, because I'm a candidate for president of the United States, can say anything, and it's all considered a First Amendment core political speech. And she not only did she completely reject that, she did that by using examples of Donald Trump himself, where statements he made would not violate her gag order and statements he made would violate her gag order, including the fact that she noted that in the 2 weeks where she had lifted the gag order, and therefore he was not technically under it, he would have violated the gag order had the gag order been in place, and she took him to task related to that. Let's get to the order, because that's the new information here on this particular hot take. It's a 9-page order. It came out, but it wasn't available until early this morning. And the first thing that Judge Chutkan does is completely dispatch the argument that there is an overriding First Amendment right of someone to interfere with the justice system. She just doesn't believe it. It's not true under the law. And what she has said is that the First Amendment must yield to the right of the public and to its participants to the, quote, orderly administration of justice. And this is a right that's not just held by the defendant under the Sixth Amendment of the Constitution, which is for a fair and impartial trial and other things related to that, but to the public. The public in the United States has a right to make sure that there are fair trials. This is the judge's quote, fair trials, which result in just judgments, and that they're done in public. And that so the First Amendment and the Sixth Amendment always have a tension, but that the First Amendment has to yield to the orderly administration of justice. The judge also took him to Trump to task because he did nothing to break the causal link, the causation link between his statements and the violent rhetoric and the violent attempts by his followers and listeners to do grievous harm to people that are participants in the criminal justice system. They just waved it off with their hand. That's irrelevant, Your Honor, she quoted Mr. Lauro as saying at the hearing, and basically concluded at the end, you've done nothing to defeat the overwhelming evidence put in by the Department of Justice that words matter. Right, we're back to the "won't someone rid me of this meddlesome priest," Henry II comment from the 1107s that the judge kicked off the hearing with. She has not gotten over that words can lead to actual grievous consequences. And Donald Trump's done nothing to refute that. In fact, Donald Trump never in his briefing outlines the statements that he's made and explains how they are somehow within the First Amendment protection. He doesn't want to put up a chart or a graph or a schedule or a spreadsheet of all those statements because he just wants to ignore them. And by not mentioning them again, not ringing the bell with the judge, he thinks the judge isn't going to notice the lack of analysis in the briefing. And the judge, of course, has. Here's what else she says. She says on page 3 of her order, defendants, that every time I say defendant, that's Donald Trump, Trump's other claims also disregard the record. That means the facts that have been developed in the hearing and the briefing. To begin with, Trump asserts that the court cited no evidence supporting its findings of risks of harassment and witness intimidation, and the prosecution provided none. That's a quote from Trump's brief. The judge goes on to say, but several times the court and the government pointed to evidence causally linking certain kinds of statements with those risks, and defendant never disputed it. And she quotes from the transcript of the hearing, quote, this is the court 10 days ago in a hearing. When Mr. Trump has singled out people in public statements in the past, hasn't that led to them being threatened and harassed, as demonstrated in the statements attached by the government? Mr. Lauro for Donald Trump, Your Honor, that's totally irrelevant. That's all he said. The court and the government's motion cites several of them who averred in the kinds of statements that you've asked for under oath that threats and harassment towards them had increased significantly as a result of Mr. Trump's statements about them. And then she goes on to say, undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. The judge goes on to conclude the evidence is in the record. Defendant simply fails to acknowledge it. And then she, after she completely dispatches with a wave of her hand the fact that Donald Trump hasn't refuted any of the evidence put in by the Department of Justice, she also reminds him again and again that every time he says First Amendment, which is really mentioned dozens and dozens and dozens of times in the brief, that's all they've got to hang their hat on, that always has to yield to anything that poses grave threats to the integrity of the judicial proceedings, which she has already found. In fact, she says on the top of page 4, or the middle of page 4, from her own findings, this court has found that even amidst his political campaign, defendant statements pose sufficiently grave threats to the integrity of these proceedings that they cannot be addressed by alternative means. And it has tailored its order, the gag order, to meet the force of those threats. It's tailor-made for Donald Trump's conduct. And then my favorite part of the brief is what I let off the hot take with, which is her comparing and contrasting recent social media posts by Donald Trump showing which ones would be okay under the gag order and which ones would violate the gag order. Again, giving him more than you normally get from a judge. Normally from a judge, you get the order. Then it's up to you to use, reasonable interpretations of plain English and language in the order, or if it's technical language, then the technical language in context, or terms of art, as we like to say, things that we use regularly in a certain field that people all know the meaning of. That's how you interpret an order. You don't get an order after order from a judge giving examples of how the order can be applied. But here we have it for Donald Trump. This is gag order for dummies provided to Donald Trump by Judge Chutkan directly. And on page, did you know that poor sleep can cause weight gain, mood issues, poor mental health, and lower productivity? Sleep is the foundation of our mental and physical health and performance in our days. Having a consistent nighttime routine is non-negotiable. When I don't get enough sleep, trust me, you don't want to be around me the next day. Introducing Beam Dream. You know we've been raving about Beam's Dream Powder. They're healthy hot cocoa for sleep. And today, our listeners get a special discount on Beam's Dream Powder, their best-selling healthy hot cocoa for sleep with no added sugar. Now available in delicious flavors like sea salt caramel, cinnamon cocoa, and chocolate peanut butter. Better sleep has never tasted better. Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, melatonin, and nano CBD to help you fall asleep stay asleep, and wake up refreshed. A recent clinical study revealed Dream helped 93% of users wake up feeling more refreshed, and 93% reported that Dream helped them get a more restful night's sleep. Just mix Beam Dream into hot water or milk, stir or froth, and enjoy before bedtime. I've personally tried Beam Dream, and it lived up to the hype. First off, it was delicious and just a lovely nighttime routine. And secondly, and most importantly, it helped me fall asleep and stay asleep. The next day, I woke up ready and eager to take on all of life's challenges and tasks. Find out why Forbes and the New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, take advantage of their biggest sale of the year and get up to 50% off for a limited time when you go to shopbeam.com/legalaf and use code CYBER at checkout. That's shopbeam.com/legalaf and use code CYBER for up to 50% off. Particularly on page 6, she says, 2 of defendant's social media posts since the order's entry, meaning the gag order, illustrate the comprehensible difference between the statements it permits and those it prescribes. All right. And before I get there, just to remind everybody who might be tuning in only to this hot take first, this is the actual gag order that the judge entered. And this is the language. It's one paragraph. So let me just read you the language. I mean, it's within a longer order, but the actual gag order is as follows. Sorry, I've got to kind of piece my way through this. All interested parties in this matter, meaning both sides, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target 1, the special counsel prosecuting this case or his staff, 2, defense counsel or their staff. She just threw that in there. 3, any of this court's staff or other supporting personnel, or 4, any reasonably foreseeable witness or the substance of their testimony. It's one paragraph. It's written in 4th grade English. Anybody could figure that out. Donald Trump spent a lot of his opposing brief arguing that, no, who could figure those words out? Those words are very complicated. Target, public statement, staff, foreseeable. Who knows what those words mean? I mean, seriously, like it was a stand-up comedy routine. So that's the order. Now, the judge said, take that order and let's apply it to two recent activities by Donald Trump to show you what's inside and outside the order. She said this statement on October the 20th, and I find it fascinating that she used this particular statement among all of them. It's one that actually has a racial connotation to it, buried within it. I'm sure you'll be able to figure out what I'm talking about when I read it aloud. But this is the one that she chose to use just to show you that she's got a thick skin here. Here we go. She says this one is okay under the gag order. This is from Donald Trump. Does anyone notice that the election rigging Biden administration never goes after the riggers? It's not a typo. It's with an R, R-I-G-G-E-R-S, but only after those that want to catch and expose the rigging dogs. Now we've got rigger and dogs as a concept in the same sentence. Massive information and 100% will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the result. Our country is being destroyed. MAGA. That's the one she used, the one with the racial overlay. Then the judge goes on to say, this statement asserts that defendant is innocent, that his prosecution is publicly motivated, and that or politically motivated, that the Biden administration is corrupt. It does not violate the order's prohibition of targeting certain individuals. In fact, it allows this assertion. So you can go off and do all that on the gag order. However, she says on page 7, by contrast, on October 24th, after the order was stayed, meaning after I lifted temporarily the gag order, this is what Trump said. I don't think Mark Meadows would lie about the rigged and stolen 2020 presidential elections merely for getting immunity against persecution by deranged prosecutor Jack Smith. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will be forever gone, and we're not at all interested in exposing those that did the rigging. If you say bad things about the terrible monster Donald J. Trump, we won't put you in prison. You can keep your family and your wealth, and perhaps if you can make up some really horrible stuff on him, typo, we may very well erect a statue of you in the middle of our decaying and now very violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards and so bad for the future of our failing nation. I don't think that Mark Meadows is one of them, but who really knows? Make America great again. The judge says this type of statement would almost certainly violate the gag order, under any reasonable definition of targeting. Indeed, defendant appears to concede as much in his own reply paper by saying if the gag order had been in effect, President Trump would have been unable to make that statement, and for good reason. The judge goes on. The statement singles out a foreseeable witness for purposes of characterizing his potentially unfavorable testimony as a lie made up to secure immunity, and it attacks him as a weakling and coward if he provides the unfavorable testimony. An attack that could readily be interpreted as an attempt to influence or prevent the witness's participation in this case. This plain distinction between this statement and the prior one, apparent to the court and both parties, demonstrate that far from being arbitrary or standardless, the gag order's prohibition on targeting statements can be straightforwardly understood and applied. She then said, if this happens again, a statement like that gets made now that the gag order is back in place, then she's going to afford the parties an opportunity to provide their positions on the statement's meaning and permissibility before she rules that there's been a violation of the gag order. She then concludes in no uncertain terms that Donald Trump has absolutely no chance or isn't likely to prevail on the merits of his appeal, and therefore she has reinstated the gag order. Now, she didn't go one step further, which the Department of Justice asked. The Department of Justice also asked her to modify the conditions of the release of Donald Trump so that if he does it again, it's an automatic ticket to jail. She will take it on a case-by-case, statement-by-statement basis instead, which I think is probably the more suitable thing to do, especially when she's got the D.C. Court of Appeals, her bosses, who are hanging over the case a bit. So we're going to continue to report on developments in the gag order. Based on Donald Trump's track record, he'll purposely and intentionally violate this gag order soon. He did it in New York in Judge Engoron's gag order, and has already been fined and had to take the stand and was found to have lied to the judge under oath. So we may see similar things here. I don't think that the judge in the future is just going to let the lawyers brief the issue of whether one statement is or isn't a violation of the gag order. I think she's going to drag Donald Trump in and have him testify at a certain point, watching the model, the template from Judge Engoron. But we'll follow it one place, MeidasTouch Network, on this YouTube channel. You knew that. That's where I do these exclusive hot takes. And then we pull it all together on a leading podcast at the intersection of law, politics, and justice we call Legal AF. It's right here on the MeidasTouch Network, Wednesday, 8 p.m. Eastern Time, Saturdays, 8 p.m. Eastern Time. And then we do hot takes, the leaders of Legal AF, about every hour, only on this network. Help them get to 2 million free subscribers on this YouTube channel. They're almost there. They're at 1.7 million. And the bigger they get, the more your voice matters. So until my next hot take, until my next Legal AF, this is Michael Popak reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.